A very good afternoon, ladies and gentlemen, and welcome to Block 4, Crossing the Digital Divide, Law, Privacy, and Cybersecurity in a Fractured World. Here at the UNBOUNDED 2025 in Singapore. I'm Louis, and I'm a principal consultant with Public Policy Asia with over 30 years of experience, shaping legal and regulatory frameworks across ASEAN, including cybersecurity, digital trade, and dispute resolution. And as the author of Cybersecurity, Guardians of the Digital Frontier, and also the strategic advisor to initiatives like Space ASEAN, I'm thrilled to moderate this critical discussion on navigating the evolving digital landscape. Today, as data laws tighten and cyber threats escalate, digital risk is a core concern for firms. Our panel of 7 distinguished leaders will explore how to address global privacy regulations, cybersecurity, readiness, AI compliance, and digital governance. We have 2 rounds of discussion, the first on privacy and cybersecurity, the second on AI and digital governance, with each panelist offering a 3-minute perspective. I would sound out a bell or I'll buzz them in the event about 30 seconds before their 3 minutes. So our panel brings diverse expertise from data privacy and fintech regulation to cross-border tech and litigation. We'll hear from Ms. Lauren Lee, Ms. Wee Kok Ree, Mr. Kumar Sharma, Mr. Mustafa Demir, Ms. Ying Yi Liu, Ms. Rishi Ganeswaran, and Mr. Mayasuki Tani, each tackling pressing challenges in this fractured digital world. Let's begin with our first round on privacy and cybersecurity. To kick us off, Ms. Lauren Lee, founder and principal consultant of North Star Data Privacy, brings over 20 years of Singapore and UK qualified lawyer, formerly Chief Privacy Officer at International SOS, guiding MNCs on global privacy strategies. So Lauren, what are the primary challenges multinational corporation faces in achieving compliance with regulations like GDPR and DPDPA, and how can they address these effectively?
Thanks, Louis. Hi, everyone. Really lovely to be here with all of you talking about data privacy, a topic I'm really passionate about. I'd say in today's world, in 2025, challenges faced by MNCs are huge in relation to data privacy, starting with the myriad of data privacy laws, one in each country, and in the US, state by state, not helpful. The last time I counted, that takes us to 167, probably more today, and layering that with AI regulations and laws. So starting with just how different each law is, so taking GDPR, for example, relying on legitimate interest, and as a lawful basis for transferring data. And then you move to Asia, especially in Southeast Asia, where consent is usually the regime. And there's a popular opinion amongst even data privacy practitioners that GDPR is the strict standard, and then Singapore is really easy, so it will be okay. But then you have nuances. For example, under GDPR, there are certain factors you need to, well, not all companies need a DPO. You have to cross certain thresholds, and if you're a smallish company, then maybe you don't need a DPO. But in Singapore, conversely, every company needs a data protection officer. So these are some of the challenges for an MNC. Also breaches, and when you have to report a breach, those are different in every country. So if you have a breach, and with digital systems these days, one breach could be a breach in every single country, and then you have to ascertain, is it reportable here? What are the timelines? Is not reportable in another jurisdiction, and so on. And of course, with breaches, fines. Fines are a real challenge. Meta got fined 1.2 billion euros under GDPR, And in China, we saw Didi, which is a ride-hailing company like Uber of China,
30 seconds.
being fined 1.2 billion US dollars by the Chinese authorities. So these are all things that multinationals have to contend with. So what's the solution to this? As a consultant to my clients, if a company comes in, they're in more than 5 countries, I would say take a baseline, right? And then zoom out and have a strategy as to how you're going to approach your privacy program. Back to you.
Thanks, Lorraine. Thanks, Lorraine, for highlighting the complexities of global privacy compliance. Next, we turn to Mr. Wee Kok Ree, Managing Partner of Fly Pipper Consulting Group, with over 25 years in deep tech, holding CISSP and AI governance certifications. Kok Ree, what critical steps should firms take to strengthen cybersecurity preparedness under frameworks like the EU Cybersecurity Resilience Act? Thank you.
Thank you so much. Very happy to be here to share about the topic on cybersecurity, which is in my DNA and also my passions. So yeah, so when talk about cybersecurity, it's very important to know the rule of law in that particular jurisdictions. Example, in US, we have this SEC disclosures rules, which you need to report if there is a material cyber incidents. So you need to fill up the form 8-K, and you also need to report annually about your company risk management, information risk management, strategy, and government. Whereas in Singapore or EU, which the latest act that's coming out last year, March, which is called the EU Cyber Resilience Act. So what it tells us is that if you are a manufacturer, which you want to import hardware or software into EU, where there's a digital element, you need to make sure that your products, whether it be hardware or software, to be vulnerability free, and you need to constantly monitor, or else EU will reject your products into that. Well, in Singapore, we have this CSA Cybersecurity Act, which, and also by end of this year, 2025, we will have another act called Digital Infrastructure Act, which is a DIA, which is the add-on to this Cybersecurity Act that we need to regulate cloud service provider and data center player. So once we know the rules about each jurisdiction needs, we come to framework. What kind of frameworks that we need to use in order to protect our environment or organizations? So we can adopt some NIST, NIST, CSF framework or risk management framework, which a lot of organizations now is doing that. And of course, if you are talking about AI, maybe you want to consider ISO 42000. And of course, the mother of this ISO in terms of cybersecurity document will be ISO 27001, which is a very good document and process that organizations can do. Can follow about the step, how to verify your cybersecurity system. So in terms of technologies that, of course, I would think of is a lot of them may be very familiar, like multi-factor authentications, then hardening of your system, make sure that the vulnerability has been removed. Then, of course, constantly monitor. That is very important. And I think a lot of organization nowadays is that we need to know is that new technology keep coming in, like AI, and the next big thing will be the quantum, which anyone knows when is the Q day that will be happening, which is telling the Q day means that the day when the quantum will break the encryptions of the current, all the current algorithms. So it's very important that we need to prepare early. Yeah, thank you.
Thanks, Kok Ree. Excellent insights, Kok Ree, on proactive cybersecurity measures. Now let's hear from Mr. V. Kumar Sharma, partner at Eldon Law LLP, who leads their technology and cybersecurity practice, advising on digital assets and fraud litigation. Sharma, what legal risks do firms face from cyber threats, and how can litigation strategies mitigate this?
Thanks, Louis. Actually, Kokri, I wanted to ask you this what is Q day?
Yes.
That sounds really scary, actually. So I've got the distinct pleasure of dealing with the fallout from cybersecurity attacks, right? And I'll split my response in two parts. The first is the trend that we see in how these attacks have evolved, and the second is how we mitigate against that. So in terms of the evolution, in the past, there were a lot of business email compromise scams, the misdirection of funds. It's rife in the commodities industry, right? You give payment instructions by email. That email is intercepted, a third party impersonates a party, and then funds are misdirected somewhere else. And the victim is faced with this risk of having to pay twice, pay the hacker and pay the counterparty, right? Business email compromise scams. And then it's evolved since then to ransomware attacks. You're seeing more and more ransomware attacks where your data is held hostage, access to your systems held hostage. And the question there is whether or not to pay or not to pay, right? That's the question that faces most of these businesses. And when that happens, I have to call Kokri and ask him whether or not he can regain access to systems, right? Restore from backup, and whether or not you really do have to pay. There's that assessment there. That payment is most likely going to happen on-chain, right, in cryptocurrency, which brings me to my third sort of category. Cybersecurity incidents concerning misappropriated crypto, right? It can be a wallet, whether it's a hot wallet or cold wallet, and you've got assets misappropriated. In all of these cases, the approach tends to be, first, go after the hacker as an unknown person, get your freezing order, try and trace the flow of monies. Second, and the approach that I think is more likely to see recovery, is actually going after the intermediary. So all the parties who contributed to or caused the attack may be liable to victims and have to recover. In terms of mitigation, there are three things, right? The first is, not many businesses know this, but there's cybersecurity insurance. Second, there's also contractual risk allocation, right? So a lot of businesses still don't put in their contracts how to allocate risk of cybersecurity attacks, and that's critical. But the third one, and the one that I really want to talk about, is something called burn and remit, right? So imagine you've got a bank account, a third party accesses it.
30 seconds.
Monies are drained, and central authority says, don't worry, I'll give you back your money. There are very limited circumstances on chain where an issuer can burn tokens in a hacker's wallet and reissue it to the victim. In other words, I don't have to go on a wild goose chase around the world trying to find money. I can just go to the asset issuer and say, please help the victim, right? Destroy the tokens there and give it back to the victim. There's no law about this. There's no law or framework, but there has to be a framework where digital asset issuers are obliged to burn and remit tokens to help victims. And it's something that we have to talk about. It's controversial, but we need it. Thanks.
Thanks, Sharma. Thank you, Sharma, for outlining the litigation's role in cyber risk mitigation. Next, Mr. Mustafa Demir, founding partner of Mark Plus Partners in Turkey, brings expertise in corporate law and AI-driven M&A due diligence. Mustafa, from a Turkey perspective, how do Turkey data protection laws compare to GDPR, and what strategies should businesses adopt?
Thank you, first of all. Turkish data protection laws, they are based on a 1995 European Union directive, and the rulemaker in Turkey enacted this rule in 2016. However, 2 years after this enactment, European Union came up with GDPR, so which made Turkish law outdated compared to GDPR. And that's why last year in 2024, Turkish rulemaker made some amendments in Turkish data protection laws. And with these amendments, the Turkish law is aligned with the GDPR, but even today, there are like some distinct differences between GDPR and Turkish data protection law. First of all, Turkish data protection law includes data localization, which GDPR does not have. And according to Turkish law, so some sectors such as banking, telecom, and healthcare, the companies who who are located in Turkey, who practice in Turkey, they have to store such information in Turkey. And also cross-border data transfers were also strictly limited before the amendments. After the amendments, still it's not like the standards of GDPR, but right now the rulemaker gives some adequacy decisions for some specific countries and specific sectors, also international organizations. After that, however, even as of today, there's still not a published, list of countries or international organizations which will have adequacy decisions. Soon, we expect it to be published. After it published, so the transfer of the data will be freely, transferred to such countries and also the organizations. High probably it's gonna be Europe, UK, and Singapore. Such countries will given adequacy decisions, and also international organizations such as UN. That's what's the expectancy at the moment. And also sensitive data such as healthcare or employee tracking.
30 seconds.
Very limited in before the amendment. Right now, it's also that's also changed. What I would recommend for the businesses is they would, comply with both the regulations, both like if they are operating both in Europe and Turkey. So it would be better if they would, for local operations, they would comply with Turkish rule, and for the international, for the European operations, they would comply with GDPR, so that they can get away from the fines, because not complying with the Turkish rules might, you might face up to
Time's up.
9 million fines, so yeah.
Thank you. Thanks, Mustafa. Your Turkey perspective on data protection is invaluable. Now, Ms. Ying Yi Liu, partner at CMS Holborn Asia. She leads their financial services regulatory practice, recognized as a FinTech 65 leader in 2024. Ying Yi, how do cybersecurity and privacy laws intersect, affecting businesses' legal duties and liabilities?
Sure. Thanks so much, Louis. So, as you may know, cybersecurity essentially focuses on systems, protecting systems against, unauthorized access or disruption, whereas data privacy is very much focused on the individual's rights and, the safeguarding of their personal individual data, and handling that, whether, how you collect, how you use that. So typically we see these two areas kind of intersect in the event of a data breach, right? Where you've heard of, the SingHealth 2018 SingHealth data breach, where, data patients was lost as a result of a cyber attack. I think, in my practice area, especially in advising financial institutions, there is an additional layer of regulatory obligations that we need to be mindful of, particularly in the space, and especially you see where in the event of a data breach affecting financial institutions. Not just, obviously financial institutions are subject to data privacy laws that, Lorraine and Mustafa have talked about, but there's an additional regulatory angle where in addition they're subject to the MES notice on technology risk management, the MES notice on cyber hygiene. So maybe just to put things into context, earlier this month there was I think 11,000 customers were affected by, ransomware attack, right? These were customers of DBS and Bank of China, and their service provider, the printing vendor that they had all the data of these customers, and it was stolen in this ransomware attack. So typically from a regulatory perspective, there are several things that we need to consider in addition to the PDPA side of things. In the first place, as banks, this customer data was subject to banking secrecy. So the sharing of that with your service provider, certain exemptions would have been relied upon to do that. That relationship with the service provider, if that was an outsourcing arrangement, that would be subject subject to the MES notice on outsourcing guidelines, which includes making sure that your service provider is subject to certain standards in terms of handling that customer data. So in the MES TRM notice, then you also need to look at notifying the MES in the event within an hour of a relevant incident, for example, then following up with
30
a
seconds.
root cause incident report. So navigating all of these regulatory obligations are fairly important for a financial institution, particularly before going to the regulator. You need to know, sometimes on a fairly urgent basis, what's your potential exposure. So it's not just to the client, but before getting to the regulator, what is the potential fallout that I have?
Thank you. Thanks, Inge, for detailing MES compliance for fintechs, etc. And next, Mr. Rishi Ganeswaran, Head of Legal Technology and Chief Privacy Officer at Yinsen Group. He combines law and engineering expertise in privacy and cybersecurity. Rishi, what practical steps can organizations take to integrate data privacy and cybersecurity into technology strategies?
I think the first thing is we need to appreciate the fact that the technology is zooming ahead in today's time. I'm talking about all the AI developments, ChatGPT toolboxes, and the legislation is just playing catch up. In EU, you have all the recent EU AI Act, AI Data Act, AI Data Governance Act. So definitely the entire globe will play catch up. Similarly, of how they were the leaders in the GDPR legislation, the rest of the world have privacy legislation popping up. So how do we go about integrating the privacy and cybersecurity aspects, compliance-wise, into growing technology? In my organization, the CIO or the CISO, as you call it, have to be best friends with the legal and commercial team. Now, it's a joint integration of how we access or assess certain portals or AI platforms and how this needs to be in compliance with the relevant law. It depends on the relevant jurisdiction. And it also depends on what kind of AI function is there at the moment. So for example, in my organization, we have EU offices. We have offices in Brazil, Singapore, Malaysia. And as we try to understand what is the scope of compliance governance we are dealing with, how tight are they, how stringent are these legislations in terms of privacy legislation and cybersecurity legislation. Once we have already understand a roadmap of a common baseline standard, given the number of country jurisdictions you're dealing with, then you can deal with how to integrate compliance into the relevant technology platform. I'll give you an example. For example, China has a cybersecurity laws, which is quite high. So if you include China in your pool of officers, then that could be a higher threshold. But if it's just concerning, let's say, Singapore, Malaysia, and the regional countries, now let's say in terms of privacy, they are not as stringent as I may say compared to GDPR. GDPR is the gold standard. So depends on the stringent levels, and then you need to do due diligence, maybe gap analysis, audit mapping into all these countries, and then you can have a better flavor of understanding of how you can go about integrating this. So it's firstly need to do a deep dive duty of what are the relevant compliance. I will call it an audit. So once you have complied this privacy and cyber technology audit, this has to be a joint effort from both the CIO's tech team, IT team, and the legal privacy team as well. And once all this has been
30 seconds.
consolidated, then we can probably go into the deep dive of how to integrate them into the technology portals. Yeah.
Thank you. Thank you, Rishi. Your practical steps for integration are spot on. Finally, we have Mr. Masayuki Tani, Managing Partner of Pro Innovation Consulting based in Singapore and Tokyo. He advises startups on blockchain and AI across borders. Masayuki-san, from a Japanese perspective, how are businesses addressing cybersecurity under APPI and what lessons can global firms learn?
Okay. Yeah, I want to start explaining incident, big incident in the Bitcoin industry or blockchain industry in Japan. So, $500 million of Bitcoin was stolen by hacker from the Japanese exchange. What was the cause or reason? That is social engineering. Engineer was contacted by hacker criminal group, and he was asked to install project, GitHub repository, and the malware is equipped. So now social engineering is getting more important risk. Maybe because ChatGPT, it's become easier. So what can we do? So first, I recommend to all companies, including startups, they should take reference when they hiring people. In Japan, reference was not very prevalent in the past, but now it's definitely necessary. Also, establishing policy and giving them education for them to fully understand. That is also very important. So, but I feel that we cannot prevent cyber security attack 100%. So we need to establish procedures in advance, and who will be responsible for security incidents. We need to decide in advance. Also, insurance can be considered. Also, I advise that in agreement with consumers or like any partner, security incident should be included in force majeure. They need to review such a possibility. So for privacy, in Japan, the unique thing is
30 seconds.
We need to take care of reputation or what people think. There are some incidents in Japan that even though company comply with the law literally, but they are very criticized. So, if you are interested, I can introduce face-to-face.
Thank you, Masayuki-san, for sharing Japan's cybersecurity approach. As we shift now to our next round, second round on AI and digital governance, we return to Ms. Lauren Lee, whose privacy expertise at North Star guides MNCs globally. Lauren, how should businesses evolve digital governance frameworks to ensure compliance and foster client trust?
Thanks, Louis. I think the first thing I'll say is it depends, right? It depends on where you are as a company, which jurisdictions you're in, what your plans are for the next 5 years, where do you want to be? And zooming out and taking a good look at that. So I'll go back to my experience at International SOS. It was pre-GDPR, planning for GDPR compliance, and therefore the whole privacy program at International SOS started with GDPR. Also, the background is that the founders are French, and we had a small group of European clients, a small group but very vocal and keeping us accountable. So that formed the basis of our privacy program, steeped in GDPR, and then building from that. But for clients coming to me today as North Star Data Privacy, I'll look at what countries they are in, and it's not always GDPR first. If you're not offering services in the EU, then it could be a different strategy. But definitely a good foundation is key, especially as companies look to jump on the AI bandwagon. What I'm seeing is that there's a lot of excitement, a lot of push to be there at the forefront of AI right now. But the faster you want to go, the better your foundation has to be. So it's really back to knowing where your data is, what applications, which functions, what data you're collecting, where is it going, and getting the core foundation right first. So that would be my advice. And also layering on geopolitics. So there's a lot of crystal ball gazing with that as to what might happen. So choosing your basis and choosing if you're a company, for example, with operations in the US, in the EU, and China today, how you would plan your
30
landscape
seconds.
would be very different from another company. Thank you.
Thanks, Lauren. Your governance insights set a strong foundation. Next, Mr. Wee Kok Ree, with his deep tech background and AI ethics certification, and who drives cybersecurity innovation at Flypaper. Kok Ree, how does AI introduce new cybersecurity vulnerabilities, and what measures should firms implement?
Thank you, Rui. Okay, so for AI for cybersecurity, actually is using a big term in cybersecurity. We use AI for threat hunting. We use AI for predictive analyzing of all the threat. Then we also want AI to do automation because hackers don't sleep, okay? So we need tools to help us, to supercharge us, enable us to be able to tackle those attacks. So AI has been using in cybersecurity for many areas, as just now mentioned, and a good framework that just now I mentioned also is ISO 42000. My advice is that before you jump into AI deployments, do consider what is your use case. Don't just because people tell AI is good, I just want to use. So for cybersecurity, definitely is a lot of use case being used. Then in order to, how do you protect your AI model? As we all know that AI need a lot of data. So hackers trying to poison the data, or they perform some kind of evasion attack or prompt injections to mislead or deceive the LLM of the model to generate some malicious output. So this is a kind of attacks. Then of course, we also need to take note of the model shifting or decay, because after some time, your model may be, producing some hallucination. So it's very important is that after you deploy AI, you need to monitor and constantly test it. And I think AI's, as just mentioned, is that a lot of companies that they want to use AI for a lot of purposes. So it's very important, you need to have a buy-in for your management, okay? Management have to buy in, and whether you need to have set up an AI government committee, okay? Without all this, deploying an AI in your environments, you will just invite more attacks. So these are the two prerequisites. Top management buy-in. Second is that AI governance committee have to be set up. And of course, lastly is, do you have resources? Okay, don't just happily deploy AI, happily use it, then you don't know any attacks that will coming in, whether it's by, you did not harden your system.
30 seconds.
Yep, you did not harden your system, you did not deploy some PET. PET is a privacy enhancing technology which is help to encrypt data. Just now we talk about a lot of data, GDPR, even in Singapore, PDPA. So data is the main source or crown jewel that hackers want to steal. So yeah, so AI is very good, in terms of it's very powerful, and I think in cybersecurity world, it helps us a lot. Thank you.
Thanks, Gauri, for addressing AI cybersecurity challenges. Now, it's Kumar Sharma, whose litigation expertise at Eldon Law tackles digital asset disputes. He'll share his insights on AI disputes. Sharma, what emerging disputes arise from AI and digital technologies? And how are legal frameworks adapting?
Thanks, Louis. Actually, I wanted to ask Kokwi a question. I know it's a bit not normal, but my concern is the use of AI to mount attacks. And that's the trend that I hear in the market, right? It's how it's evolving. I mean, what's our reply to that? Is there a reply?
Then we use AI attack back or defense. We be the blue team, the other side is a red team. So hackers, we consider them as a red team, which they keep attacking. Whereas for us as a defender, we call ourselves blue team. So we need to put in a guardrail to ensure that our model, our data are not contaminated. Thanks.
Yeah, I just find it bizarre that now we're dealing with a contest of AI when it comes to cybersecurity breaches. Right? That's it's the next movie, probably. But back to the initial question, right? What disputes are emerging? We've got the bog standard one that's been around for years, copyright infringement and fair use, whether or not you can rely on fair use defense. It's a recent case in the Delaware Federal Court, Thomson Reuters and Ross, where Ross essentially used Thomson Reuters hit notes to prepare legal memos through a third party. Court said that's not fair use, right? And as a result of this, I think we're going to see a lot more businesses settling in the event there's a copyright infringement claim, unless because they're in Singapore, and we've got a specific defense, computational data protection analysis, the CDA exception in the Copyright Act, that some businesses can hope to rely on if certain conditions are fulfilled. Right, so copyright infringement, that's the first one. Second one, deep fakes, okay, AI deep fakes. And I've not come across a publication yet, but there are rumors or rumblings that deepfakes may be used to circumvent KYC, know your clients, on centralized exchanges. See, I've let the cat out of the bag. It's an issue. It's an issue that we need to deal with. And I think that exchanges are aware of this, and they are trying to AI versus AI now with the deepfakes. That's the next big problem, impersonation, right? How do we verify that? Of course, we've got the traditional methods of testing facts at trial and all of that, but ultimately it might very well boil down to AI versus AI. The other sort of disputes revolve around competition. Competition over compute. AI compute, and you can see the biggest case right now in the US
30
is
seconds.
OpenAI versus Musk, compute, talent, the fight for talent, right? So you're going to see a lot more restraint or trade clauses being tested in court. And finally, data. Trading data sets as a commodity. How do you ensure that you don't infringe copyright? And at the same time, when you trade data, you protect privacy. And there is actually a solution, funnily enough. I think Singapore does have it right in having that CDA exception. But there's also something called zero-knowledge compute, a technology that can be used on blockchain. In other words, your input can be encrypted. The output, nobody can see certain parameters of the data, and you can still trade it. Right? Zero-knowledge compute might be one way to solve this idea of trading data while preserving privacy. That's it for me. Thanks.
Okay, thanks, Sharma. Your perspective on AI disputes is critical. Next, Mr. Mustafa Demir, leveraging legal tech at M+ Partners, advises 30 years tech startups on AI compliance. Mustafa, from a 30 years perspective, how are businesses preparing for AI's legal and ethical implications?
Thank you once again. First of all, for Turkey lacks an AI act just like Europe. Currently, we do not have such an enactment. At the moment, businesses are run mostly in the legal environment. It's like more like the personal data protection rules are the rules are on the table, and so companies at the moment they mostly they have to comply with the rules of data protection rules in Turkey, and especially they need to do they are doing data protection impact assessment tests to comply with the regulations in Turkey. And at the same time, the businesses in Turkey, like the legal teams of a business and also the data scientists of the businesses, they work together so that they can prevent any bias of the algorithms or any problems that might occur, anything that might lead to a conviction of a fine. So this is since there's no any how can I say that, the regulations, and there's actually also no regulations at the moment. Just there are some sector-specific guidelines, And also there are some sandbox environments for some specific businesses such as healthcare and finance, so that these businesses can use real data to develop their algorithms with real information. Except for this sandbox, mostly the businesses, they develop their algorithms with the data that are not in real data that are on the table. That's this is the case in the Turkey at the moment. Thank you.
Okay, thank you. Thanks, Mustafa, for Turkey's AI insights. And now, Ms. Ying Yi Liu, rising star in Singapore's fintech scene. She guides AI-driven fintechs at CMS Holborn Asia. Ying Yi, what are the main legal challenges with AI-generated content, particularly regarding IP ownership and accountability?
Yeah, thanks so much for the question, Louis. I think, obviously with AI developing and moving so quickly, a lot of the time, some of the issues that we're concerned with, particularly for financial institutions, kind of deploying and adopting AI is not just, copyright and issues that, Sharma has talked about, but as you will know, in Singapore, we don't have an EU Act, AI Act. We have left it instead to sector-specific guidance, right? So for financial institutions in particular, the MES, I think, has developed and issued a lot of sector-specific guidance, setting out frameworks and guidelines that you can look into in terms of launching and deploying an AI. And I would say that, from my experience, the MES is probably one of the more proactive regulators in the space in terms of embracing AI use. So they have come out and said things like, we absolutely do encourage that in terms of fraud detection, back-end AML, risk management. So when you talk about deepfakes, for example, and AI versus AI, these are certainly things that, it's top of mind and it's stuff that we have already, considered. And in contrast to, I've been in some discussions with other regulators where the conversation is still very much, if a financial institution is adopting AI, then who bears the risk of liability, right? Who is responsible for that? And that's a fair question, especially with, some of the case law that's coming out of the US. I think that's certainly a debatable question, but, in Singapore, for financial institutions, we have a very pragmatic approach, and I think that's also aligned with some of the case law coming out of EU and the UK, which is, if you're deploying the AI, then you certainly need to be responsible for that. So we've seen, frameworks coming out with the FEED principles launched back in 2019, where MES had a Veritas initiative, and they said the key things you need to focus on in terms of AI governance, fairness, ethics, accountability, and transparency. And as you know, with AI risk, it continues to evolve. So beyond just AI, we're now seeing increased adoption of generative AI, and Gen AI use. We have Project Mindforge, which is looking at developing frameworks to address that. So it's certainly something that's very much adopted in the Singapore FI space. Thank you.
Okay, thanks, Ying Yi. Your insights on fintech governance are compelling. Next, Mr. Rishi Ganeswaran, Yinson Group Chief Privacy Officer, who ensures AI accountability in energy tech. Rishi, how can organizations establish accountability mechanisms for AI-driven decisions to mitigate risk?
I think what we can do is, as I said earlier, review whatever AI applications, how they process our data, try to form some kind of a data governance lifecycle map on how the AI collects data, processes data, and at the end of the day, the end of collection of data, where does the data reside at the end of the day? Is it deleted? Should we delete the platform? Where does the data go? Who processes it? So all of these questions need to be asked at the onset, even before you onboard the AI, which is why all our IT teams, they have this due diligence process where we consult the relevant stakeholders and engage them in how this AI is being used by legal, by privacy, by AI, by even the tech teams, and then we'll be able to form some kind of a risk analysis assessment and then we can able to choose a suitable vendor. Some vendors are not so forthcoming in terms of how they process this AI data. They say that yes, it's all yours to use, but on the sidelines they can slowly peek at certain data, personal data or confidential data otherwise. The more transparent AI features, they are more forthcoming in how they process their AI functioning, and they're able to give more clearer answers. So at the end of the day, we need to choose a vendor who is able to answer and give the right answers to the right questions that we give to them, and we are able to identify what are the risks in the realm of processing AI data processing by the various vendors. Yeah.
Thanks, Richie. Your accountability mechanisms are vital for AI ethics. And finally, Mr. Mayuki Tani, with your Japan-Singapore tech expertise, we support startups on AI and blockchain. Mayuki-san, from a Japanese perspective, what legal challenges do tech firms face in adopting AI and blockchain, and how are they addressing this?
Okay, so in AI, in Japan, they are taking approach of using existing law instead of enacting a new AI law. So, and I can say Japan has a good regulatory environment for AI. So copyright law has an exception for machine learning. Also, anonymized data can be shared, even though the data was originated from private data. Yeah, and the government are supporting AI a lot. So they are issuing guidelines. So now, actually, the technology evolving, so the companies catch up, but there are no very difficult issue in AI. So in blockchain, so I think essentially the most important thing is how the people in the industry can show why or how blockchain are useful for people, not only for tech geek, for general normal people. So and in Japan, first, the industry companies have a self-regulatory organization. Also, they established a study group with politicians of ruling party who are familiar with technology. And they are always referencing case study of blockchain, or for example, like how blockchain can be used in rural area or to develop or help farmers, or such kind of things tools are used by Japanese blockchain industry. Yeah, thank you.
Thank you, Mayuki-san, for eliminating Japan's tech challenges. That concludes our panel, and let me just offer a very quick summary. Our panelists have provided invaluable insights on navigating privacy, cybersecurity, and AI governance in today's digital landscape. From global compliance strategies to regional perspectives on Turkey and Japan, and also various other jurisdictions. We have explored practical steps and legal frameworks to address digital risk. Key takeaways include the need for robust governance, proactive cybersecurity, and ethical AI adoption. As digital transformation accelerates, this discussion underscored the importance of collaboration across borders and sectors. Please join me in thanking the panel for today. Thank you.
Thank you, sir. Thank you to all the panelists for the thought-provoking session. Now we would like to proceed for the break. We have 15 minutes tea and coffee break. Please enjoy yourselves. Don't forget to mingle. Don't forget to collaborate. And of course, the selfie, the